Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for
Well, hello. Hi, Vicky. How are you doing? I hope everybody is doing so good. Happy Saturday night. Yeah, nothing is ever the way I leave it. Anyways, I hope that everybody is doing so good. Lady in Red, that's right. We are going to watch 2 court hearings if we can get into it quickly. So we shall start lickety-split quick. That's right. Head on over to Judge Vonda Bailey for a quickie. No, not really a quickie. A 30-minute quickie. Do you consider that a quickie, Brooklyn?
I received 3 exhibits from Mother. Some have requested relief.
Oh my God, I'm embarrassed. We didn't even travel by flu powder. Oh my God. Wow, that's an easy mistake, Paisley. Can we fix that, please? Anyways, now we're on the right screen and you can see it too. Ladies and gentlemen, boys and girls, not boys and girls. Hi, John. Let's go.
The Review 360 as well as the school records. And then I received the overview of special education from, is that still from Mom?
That's
Oh,
Mr.
Father's
Corbello.
Okay. All right, both sides ready to proceed?
Yes, ma'am.
Judge.
All right, you ready, Julie? We're on the record in cause number DF1909575. Councils, would you please announce for the record?
Michael Brummett, attorney for Ryan Corbello, petitioner.
Lisa Garza for Tony Colecci.
All right, with those who intend to testify, please remove yourselves off of mute and raise your right hands.
Yes, ma'am. I'm right here, and my date was great.
All right, do you all swear testimony you'll give with the truth and the whole truth?
I do.
I don't know who that was.
That wasn't me.
Oh, okay. All right. So prior to going on the record, there were some exhibits that were pre-admitted. They will be admitted at this time. So Mother's exhibits 1 through 3 are admitted, and Father's exhibit 1 is admitted. All right. So you all are set today for an appeal. This is Mother's appeal from an associate judge's report from December 11th of 2025. You all will have 15 minutes per side. That will include any opening and closing statements should you choose to make one, as well as any examination. Attorney Brummett, at this time, would you like to make an opening statement?
I'll reserve maybe a close, Your Honor.
All right.
This is Father's appeal.
We filed a counter, I believe, Ms.
Yeah, we're
Garza
not
indicated.
pursuing our relief. We're going to stick with Associate Judge Lee's report.
Okay, let me pull up the okay, so it's going to be the counter appeal.
Yes, Your Honor.
Yes, Judge. And I believe we told Judge Lee, if memory serves, but maybe I just didn't communicate it clearly.
Okay. So let me make sure. So it's the same associate judge's report, just the counter requests.
Correct, Your Honor.
Okay. All right. So that is cleared up for the record. Attorney Garza, would you like to make an opening statement?
As to father's relief, yes, Judge. Father is seeking to change the schools, and we would ask that that not occur. Because the school year is almost completed. This child has special needs, and that would not be in the best interest of the child. And we would ask the court to adopt the rulings of the associate judge.
Thank you, counsel. Attorney Brummett, you may call your first witness.
I'll call Ryan Corbello, Your Honor.
Okay.
Mr. Corbello, you state your name for the record.
Ryan Corbello.
And Mr. Corbello, there are 4 children the subject of this suit. Is that correct?
That is correct.
And does your oldest son primarily reside with his mother, Miss Colecci, at
Yes, he
present?
does.
And the remaining 3 children, your youngest son and your 2 daughters, they primarily reside with you and your wife in Louisville at present?
Yes.
How long have your 3 youngest children been primarily residing with you in Louisville?
Since last February.
Okay, and this suit was initiated in March of last year?
Yes.
Okay. Does the December 11th, 2025 dated AJ report that we're here on appeal from, does that order you to ensure that the Louisville ISD schools that your 2 daughters attend will accommodate their respective educational needs and behavioral needs?
Yes.
That AJ report allowed the 2 children, your 2 daughters to transfer from what I believe was Greenville ISD schools to Louisville schools?
Yes, that's correct.
Okay, and they've been attending that school since the beginning of the fall semester?
The spring semester.
I'm sorry, I misspoke. Thank you. Is that right? And is the Louisville school in your neighborhood that your 2 daughters are attending, are they accommodating their needs?
Yes, they are.
And is the school in the Louisville district that your youngest son, who resides with you, Benjamin, that he would attend in Louisville, is that school capable of addressing and accommodating his special education behavioral needs?
Yes, they are.
Okay. With the exception of, I guess, 1, 3 of the 4 children have noted special education and behavioral needs that were the subject of ARDS and special education assessments and instituted programs, specialized plans for their individual needs. That's been the case for years. Is that right?
Yes, sir.
Okay. Did a hearing occur before Associate Judge Lee on this case on December 11th of 2025?
No.
Was a hearing scheduled to occur that day to address the school districts of attendance for the children that are in your primary custody?
Yes.
And was December 11th a reset date from November 20th, which was the date the hearing for that purpose for school determination was originally scheduled to occur before Judge Lee?
Yes.
Okay. And on December 11th, as with November 20th, did you have both of the special education diagnosticians for both of the schools in the Louisville ISD that the 3 children living with you would be attending? Did you have those special education diagnosticians under subpoena to provide testimony on the 11th and
Yes, I did.
December 11th and November 20th?
Yes, I did.
Did either of those witnesses testify?
No, they did not.
Did any witness testify on either November 20th or December 11th of last
No.
year
No one testified.
for either party?
No.
How did Associate Judge Lee arrive at her December 11th dated ruling?
Objection calls for speculation.
Sustain, rephrase.
How were you you made aware of Judge Lee's December 11th ruling?
We were dismissed, and then she said she would email the attorneys.
Okay, did I provide you
Objection,
that?
hearsay.
Sustain as to what she said.
So to be clear, no hearing was held, correct, Mr. Corbello?
No.
And later that day, did I email you the AJ ruling that we're on appeal here today? Did I email that to you late in the day on December 11th?
Yes, you did.
Do your two daughters that attend school currently in Louisville as a result of Judge Lee's, is the fact of their attendance currently in Louisville schools a direct result of that December 11th dated AJ report?
Yes.
How long do your daughters spend in the car getting to and from their local school in Louisville each day?
No, we don't take the car most days. They walk.
What time do the girls wake up to go to school each day?
They wake up about 6:45.
What time? And Benjamin was the AJ report that we're here on appeal from said Benjamin was staying in the school he was at, correct?
That's correct.
And that's in Garland ISD.
Yes, it is.
And what time does Benjamin have to get up
We
in
get
your
Benjamin
home?
up. We get him up about 5:15 in the morning.
Okay. And how much time does Benjamin spend in the car just with you or your wife transporting him to school each day in Garland?
About an hour to an hour and a half.
What time do your daughters arrive back at your home each day after their Louisville school dismisses?
They're home by about 3:20,
What time does their school dismiss?
3:10.
What time does Benjamin arrive back at your home each day after you go to pick him up in Garland ISD and get him back to Louisville?
At the earliest, 5:15 to 5:30, and some days it's 6:30.
How much time does Benjamin spend in the car just coming home from school in Garland each day on average?
An hour and a half to over 2 hours.
So how much total time is Benjamin spending in the car just for the purpose of commuting to and from school each
At,
week?
at least 15 hours.
Oh, that's a lot. That's a
Um,
lot. Hi,
how does that
Carla.
additional time it takes Benjamin to get to and from school from your home in Louisville to Garland, how does that affect Benjamin?
So he has a lot less time to do his homework because he has such a compressed day from when he gets home. He has less time to do any extracurricular activities, either at the school or at the community center that he showed interest in. During that time, he's not, he's alone. He's not with his siblings, which he enjoys spending time with his sisters in the afternoons, but it's just such a compressed schedule. Some nights, depending on how late he arrives home, even he has to eat dinner at the table by himself because the girls have already eaten. So, we try to sit down with him, but he's alone without his siblings at the dinner table, which is pretty tough on him.
Do they bathe morning of school or night prior?
They take baths at night.
Okay. Do you believe it's in Benjamin's best interest to continue commuting to and from Louisville to the Garland ISD rather than attend school in Louisville in your neighborhood?
No, I do not believe that's in his best interest.
Are you asking the court to order that Benjamin also be allowed to attend school in Louisville, as is the case with your two girls who primarily reside with you and have since February of last year?
Yes, I am.
What kind of difference do you believe that's going to make for Benjamin in terms of how's that going to benefit him from the elimination of all that road time, windshield time going to and from Garland?
Yeah, I think primarily one of the main things is it'll give him more time to do homework and his social skills with after school activities and spending time with friends and, spending time with the family. I think those are probably the two biggest things that he's missing out on right now.
Before the original hearing was set to take up the issue of which schools the children in your primary custody would attend, before that was scheduled, did you pre-enroll both your daughters and your youngest son Benjamin in the Louisville schools with the consent of Judge?
Sir, Michael. We're saying hi to Legal Fiction. What a late fee indeed. Nice to see you. And thanks for waking me up there a little bit. My monster's almost like on board now. And my mind is feeling sad for these kids. I despise it when parents can't sort their shit out to help their own children. It is crazy. That does seem like a lot of driving, but in Texas, it's not exactly that much. And I was about to say that, Vicky. I heard legal fiction. I heard a rumor. A little birdie, pray tell, said that you have started a channel. Make sure to drop the link. We'll get the link set up in a command for you if Cellulite Yoga Pants is around. Otherwise, I'll have to dust off how to learn how to do that today too, which would just stack. I will make sure to give it a follow. But honestly, driving that long in traffic, is that normal? Is that normal? Is that normal? No, John. I've never drank alcoholic Monster. No, 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 no. No, 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 no. Stuart's body cam reactions. I love it. I love it. We're going to give it a sub. Give it a follow. Woohoo.
Actually,
Yes, we did.
okay. And so are you aware that, I mean, they established, did the Louisville schools establish a plan, Special Education Institute that plan for your daughters?
Yes, they did.
Were they provided a copy of the ARD, the last ARD for Benjamin, and were they prepared to arrange all the necessary accommodations for Benjamin as well?
Yes, they were given all the information from his prior schools.
Is it your understanding that if he were to transfer in next week, tomorrow, next month, Louisville's ready to go with Benjamin?
They are ready to go. They had a full schedule and transportation services already established for them.
And again, just to be clear, there wasn't any, even though we had witnesses under subpoena, you were present, Ms. Colecci with her former counsel, and everyone was present with witnesses. We never had a hearing on this.
No.
I'll pass the witness.
All right, Attorney Garza.
Yes, thank you, Judge. If I'm hearing you correct, you're saying that there was no hearing on this issue, is that right?
That's correct.
Then don't you think this issue ought to be brought in front of Judge Lee if there was not a hearing on this particular issue?
I don't know how that would work. I would defer to my counsel.
Objection calls for a legal conclusion.
Based on the temporary orders that were prepared by your counsel, what do you think Judge Lee got wrong?
What do I believe Judge Lee got wrong?
Yes.
I wouldn't say wrong. I'm just appealing because I believe that Benjamin should be going to school here in Louisville where he currently lives.
Well, don't you believe that Judge Lee's associate report rulings reflect the best interest of your children, all of your children?
I do not believe that reflects his best interest, in my opinion.
Okay, so you're telling us that you don't think Judge Lee ruled in Benjamin's best interest.
I don't believe that that is in his best interest.
Garland ISD also has special education programs for Benjamin, is that correct?
They do, yes.
And he is getting the same services in the Garland ISD as he would get in the Louisville ISD, correct?
Yes, ma'am.
I'll pass this witness.
Okay, anything further, Attorney Brummett?
Just briefly,
Bill.
just to be clear, Mr. Corbello, is it your understanding a hearing was scheduled for the sole and express purpose of determining, which was a report back that's in Judge Lee's original April 22nd, 2025 AJ report, a report back hearing on the schools that the children would attend? Is that's your understanding?
Yes.
And that hearing, due to circumstances with the court's docket, was reset from November 20th to December 11th.
Yes.
And so you understand that our intentions were, we subpoenaed people to be there, that they were going to give testimony at that hearing. had there been a hearing. Is that your understanding?
Yes, that's my understanding.
Okay, and whether Judge Lee or any judge decides to have a hearing or not, we really don't have a say in that, do we?
No, we do not.
Um, after the April original temporary order AJ report, um, the three children in your primary care were about a month from being released from school for the summer recess, right?
Yes, sir.
Okay, and so everybody expressly said, let's leave them in the school districts where they're at to finish out the spring semester before the summer recess.
Yes.
Okay. And that report back would seem to be put in there to readdress that, which was ordered to occur during the summer. Is that right?
That's correct.
And due to other hearings that occurred in this case, it wasn't addressed until, or wasn't set to be addressed until November 20th, and then reset to December 11th.
Yes.
Now, all schools have special education programs and assistance and resources for children in the district. Do they not in Texas?
They are supposed to, yes.
3
Right.
minutes, counsel.
I'm sorry, Your Honor.
3 minutes.
I'll pass the witness.
Okay.
Nothing further of this witness.
All right, Attorney Brummy, you may call your next witness.
I'll rest.
Okay. Attorney Garza.
Thank you, Judge. I'll call my client, Tony Colecci.
Okay.
Okay, here we go.
Please state your name
Mom.
for the record. Hold on.
Okay,
You've
please,
got
hold on,
really
hold on,
bad
hold on,
feedback.
hold on.
I think she has two.
I talk about Bruno. You lived in Tennessee for a year back in your mid-20s, and the South is not for you. You talk much faster than your neighbors and have learned no patience. You have no patience. Reminds me myself. I am a bit of a fast talker, I've been told. A bit of a fast talker. Anyways, that, by the way, the judge is doing a peace sign. Love it. Appealing to my millennial self. Secondly, why is it echoing? It's not mine. It's not my fault for once. For once.
Two profiles up.
Does it?
Yes, it says,
Okay.
yeah, you see the one with the picture of the children?
No. Hold on.
But now it's perfectly fine. So why
I
are
can hear
we?
you clear now. I think it's because you muted where we can see you.
Okay, is
Okay.
that okay?
Yes.
Okay.
Legal Fiction is with Tony right now.
Uh-oh.
Okay, I'm just going to start all over, Judge. State
You're
your
good.
name for the record.
Tony Colecci?
And Ms. Colecci, this appeal is over the subject child whose name is Benjamin. Is that correct?
Yes, ma'am.
And tell the court, what is Benjamin's age?
13.
And where does Benjamin currently go to school?
Sellers Middle School in Garland.
Does Benjamin have special needs?
Yes.
Describe to the court the special needs regarding his education that he has.
So he has autism, depression, emotional disturbance, ADHD. He requires contained classroom, which Garland does provide. Louisville does not have what they call an ABC unit.
I'm gonna
So
object
what would
for- I'm gonna
happen?
object. I'm gonna
I've
object.
already called.
Hold on 1 second, ma'am. Counsel, what's your objection?
My objection is she's speculating, or take her on voir dire to determine how she's able to testify to that.
You can take her on the voir dire.
Did you call the Miss Colecci, did you call the Louisville school district or visit the Louisville district and make inquiries
Yes.
about services?
Yes, I called the middle school that's close to Ryan's location and spoke with the special education director there.
Okay, and what you just testified to is something that individual at that specific school you just referenced. Is
The
that,
whole
that's some-
district.
you said you spoke with the the special education director at the school.
Mhm. And she said the whole district does not offer.
Objection, hearsay, Your Honor.
Sustain.
So your your testimony a moment ago was based on what you were told by somebody in the Louisville district?
No, sir, you can pull it up online. It shows on their website as well.
Well, you didn't produce that, so I'm not looking at it. But you just testified that that was what you were told?
Yes.
Objection, hearsay, Your Honor.
Sustain.
Did you contact the Louisville ISD Special Education Department?
Yes.
Who did you speak to?
I cannot remember the name.
And
Not
did you also
helpful.
check on the website regarding services that were provided?
Yes. And what would happen is when a student with special education needs transfers in, there's an immediate transfer ARD where everyone says, yes, we will accept this and try to adopt everything. They have 45 school days to collect their data. If they don't have something that was on the previous IEP, they use this data to go to ARD and say, hey, we don't have this, but we can offer this or this, because according to the data, this is what would best fit his needs. Now, if they have something else that he needs somewhere else or in a local district, they will provide transportation even out of district if the child needs something that somebody else has.
After you spoke to that individual and looked online to investigate the services that would be provided to Benjamin, what services does Garland ISD provide that Louisville ISD does not provide?
The autism unit that he's been in, he was 3.
And I think you'd mentioned ABA, is that correct?
Correct. Applied behavior.
Hold on. Tell the court what ABA is.
Applied behavior analysis. It's a technique used when working with autism children. It's also a therapy provided outside.
Are you also in the educational field?
Special education, yes.
And where are you currently employed?
Greenville.
And what do you do for the Greenville ISD?
Speech therapist.
And who do you provide services to? Like special ed or?
Yes, a number of children on campus, ranging from autism, apraxia, speech delay, pragmatic skills.
And based on your investigation, which district meets the needs of Benjamin's education?
Garland, that's why I didn't even have him here.
Are you asking the court to adopt the rulings of the associate judge?
Yes.
Tell us why you believe that is in the best interest of Benjamin.
Because they continue to have services that he needs. He is not doing very well here since he's been living with dad. He is currently on what we call a safety plan, which means he can't travel through school without one-on-one support due to behaviors.
Oh my God,
like
sending Jeff good
saying he
vibes.
wants to hurt himself or actually hurting others. He's been suspended. He's had numerous lunch detentions, having to have lunch in the classroom because he's just not functioning this year.
And what do you attribute the change in his behavior to?
The change of his living environment.
Have you spoke to Mr. Corbello about that?
Yes, I have asked that we move forward with starting the therapy.
What
And
therapy?
is ABA. He's already in counseling. I've asked for more time at home. I have a number of people that can help out with Nathan so that he is not in the presence of Benjamin. My mother's even offered to take custody of him in Arizona. There's a great autism school there for him.
All right. Is there anything else you want to tell this court about Benjamin as it relates to his best interest in keeping him in the Garland ISD?
Other than the trial time, when I did bring him to Greenville, he has been in Garland schools since he was 3. They know him. The special education teams know him quite well. They know me. And they have always been able to provide anything that he needed for him.
Based on Benjamin's special needs, is it difficult for him to make a change in his routine?
Absolutely.
Okay, I'll pass this witness.
Okay,
All 4 children have special needs, do they not, Ms. Kalechi?
Yes, they do.
And if Benjamin was still attending school in Greenville, Texas, you would be arguing to keep him there, wouldn't you?
No, that's why I took him out. They can't provide for him
He
here.
didn't
And
get-
since
he
we don't
didn't
live
get-
here.
He wasn't told to transfer because of an altercation that involved a chair and another student?
No.
Okay, so you're saying you voluntarily moved him to,
Y-
had him go
yes.
to Garland.
They don't have the autism unit here.
Objection, non-responsive, Your Honor.
sustain.
You don't take either Nathan or Benjamin to school on the days that they are staying overnight, and Nathan lives with you, but with Benjamin, when he's staying overnight, he rides the bus to school, as does Nathan, correct?
They have all rode the bus. Yes.
Because you have to be out at about roughly the same start time out at the Greenville district.
Start time 7:30 for me.
But it's too late to you leave and they ride the bus.
Yes.
Did you speak to Miss Grabendike at the
Yes.
Louisville ISD? You sure it wasn't Miss Legg?
It wasn't too?
Did
Miss
you say
Lay.
Miss Lay?
Legg, Legge.
What's her title?
Do you know what title of the person that you spoke to, what their title was?
Gravendike. I believe she's Victoria's teacher.
I believe what?
You believe
She's
what?
Vic-
ma'am?
I believe she's Victoria's teacher.
Okay. Did you speak to a Miss Legg at the Louisville ISD?
I'm not sure what's her title.
She's the special education diagnostician.
Okay, then yes, I've spoken to her.
And if I told you that Miss Grabendike was also a special education diagnostician at the Louisville district at a different school campus, would that surprise you? It's not an educator?
Relevance as to whether or not it would surprise her.
Sustain. Counsel, that was your last question. You just ran out of time.
Okay,
Attorney
thank you. Your Honor.
Garza, you're welcome. Anything further?
Just so that the court knows, what was the reason you removed Benjamin from Greenville ISD?
They don't have an autism unit here. We tried him in gen ed, and the classes are way too large, like 40 plus kids, and he didn't do well.
Thank you. I'll pass this witness, Judge. Rest
Okay,
closed.
all right. Thank you. The court is going to adopt the associate judge's report from December 11th of 2025.
Thank you, Judge. May we be excused?
Yes, thank you all.
Thank you. Thank you.
Have a good
Wow,
week,
very
Judge.
You
rarely.
too.
Appreciate your time.
Thank you.
Yes.
Oh my God, that very rarely happens where she just ruled no pontification, nothing. Just just the fucking ruling. Wow. 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 That means we have time for another. I'm going to make blueberry muffins tonight. I'm going to stress bake tonight. Stress bake tonight. Judge, don't look so
All right,
surprised.
we're just waiting for Mr. Martinez to get back in here. I closed the rooms. So you should have gotten a notification. All right, Mr. Martinez, Miss Alcala, can you both hear me okay?
Yes.
Mr. Martinez, can you unmute yourself,
There's
please,
that
sir?
smoke detector.
Yes, I can hear you.
There you go. Okay. All right, then I'm going to call for a hearing, Hale County cause number A40580-1510, styled in the interest of Harley Rain Martinez, Amory Francine Martinez, Charlotte Francesca Martinez, and Vivian Francina Martinez. We're here today on the Attorney General's first amended suit for modification of support order. Motion to confirm support arrearage, which was originally filed on November 19th of 2026 and is docketed before the 64th District Court of Hale County, Texas, being heard today by order of referral by the Associate Judge for Child Support Matters. Is the Attorney General's office ready, Mr. Bunishek?
Ready, Your Honor.
Okay. Did you want to make an announcement about the pleading?
Yes, Your Honor. 1 moment. Sorry, I've minimized everything.
Minimized it.
Yes, Your Honor, we're going to non-suit our request for modification of child support and just proceed on confirmation of arrears.
Okay. All right. And so, Mr. Martinez, are you ready to proceed on the Attorney General's motion to confirm child support arrears?
What is that? What is that directly? We're going to start a new child support modification?
Not today. All they're trying to do at this point is
Okay.
take a judgment. I do understand that you all were married after entry of the last order in 2018. You guys were married to each other again in 2023. So that effectively extinguishes the ongoing child support obligation, but that obligation did exist until the time you were married. So that's what they're trying to take a judgment on, until that
cream?
point.
Yes,
Does that
ma'am.
make
You
sense?
can make butter.
Absolutely, yes.
Okay, and then I think that the understanding is that if they want to go forward with a new action for that it covers conservatorship, visitation, all of that, that will need to be refiled as a new what we call suit affecting the parent-child relationship,
Yes, ma'am.
and may have a new cause number. I'm not sure how the Hale County District Clerk's Office will handle that, but it
How the
may very well
hell?
have a different cause number. So this case is separate because the order was done prior to your remarriage to Miss Alcala. Okay.
Yes, ma'am.
Okay. And Miss Alcala, are you ready to proceed on the confirmation of arrears?
I am.
All right. Okay, Mr. Bunishek, you may proceed, sir.
All right, Your Honor, I'll offer first the marriage license between Mr. Martinez and Ms. Alcala, showing that they were married on December 31st, 2023.
A New
Okay,
Year's
let me
Eve
see if I
wedding.
can. You put that in my box.
Wedding.
Yes, Your Honor.
Okay. Is there any objection to the marriage license for the 2023 marriage coming into evidence? Mr. Martinez,
No, ma'am.
Ms. Alcala?
No.
All right. It will be admitted as State's Exhibit number 1.
And I'll offer into evidence the Attorney General's pay record. It is an updated version of the copy that was attached to the pleading, and I offer that as State's Exhibit number 2.
All right. Is there any objection to the Attorney General's pay record in this matter coming into evidence? Mr. Martinez?
I didn't understand fully. What do you mean by
He doesn't
that?
understand, Judge. He doesn't understand. Now I'm understanding why this hearing, which is completely uncontested, is going to take an extra 8 minutes, Mikey. Also, they got married on New Year's Eve. How cute. But it was for the second time. There's a few people in the chat that have done that. No judgment. No judgment. Hope you are well.
So the Attorney General's office keeps a record of payments received or payments that have accrued and what has been paid, and along with interest that accrues on those amounts. He is, and there was a copy of that attached to their motion, both the first motion they filed and then this first amended that they have refiled. There's a copy of that attached. This is an updated version of that, and so he's asking that that be admitted into evidence. Do you have any objection to that, sir?
No, no, ma'am.
All right, it will be admitted as State's Exhibit number 2.
And stay rest, Your Honor.
Okay, Mr. Martinez, Mr. Bunishek has rested. I guess what he's asking for is a judgment as of December 31st of 2023. Is that the date that you all were married? That's what he's asking for. Do you have any witnesses or evidence you want to present, sir?
We got married at the church.
I'm sorry?
We got married at the church.
Okay.
Cool.
That's fine. That's I mean, it doesn't matter where you got married, you got married. So do you, and I guess what he's asking for is this correct, Mr. Bunishek, a judgment for $38,812?
Judge, we were married by guys that used to work at a radio station. Is that okay? I just want to hear that one day. I want to hear that one day in a court case. You were married? Well, I was married, but it was by some radio guys. Why is everything so weird today? Today is like a weird day. Yeah, Bill, are you coming? You're coming up on your 50-year anniversary. What are you doing? You have to start planning now.
In child support arrears and $11,444.93 in medical support arrears.
Both as of December 31st, 2023. That is exactly what I'm asking for, Your Honor.
Okay, Mr. Martinez, are you entitled to any credit for other amounts paid, or do you agree with this judgment amount?
Yes, I had switched my address over. Before we got married, I switched my address to 2022 before we got married. So I was there longer than before we got married. I was taking care of my kids longer.
Okay, so
married.
when did you move? When did you and Miss Alcala begin residing together again?
We got back together after me and my other wife, ex-wife, separated.
Okay.
And then we went through a divorce. We got separated in 2021.
Okay. When did you move in with Miss Alcala?
That year of the Christmas of 2020.
That's right. Ditch the old wife, get the new one. I bet she's more fun. Maybe she'll even forgive your child support debt, buddy.
21, didn't switch my address and probably till after 2022.
Okay, so, but your testimony is you moved back in with her and the children the end of 2021?
Yes, ma'am. I have videos of me there at her apartment, Christmas, holidays with my kids. Yes, ma'am.
Pornos.
I have proof.
Okay. All right. All right. Anything else?
No, ma'am.
All right. Ms. Alcala, do you have any witnesses or testimony you want to offer?
I do not.
Okay. Did he move back in with the family the end of 2021?
Absolutely not. He moved to Colorado and we.
Oh my God. Oh my God. What? Not what I was expecting. Do you think that that's what Francisco was expecting, though? Do you think so? They are married right now. Keep that in mind. This is a currently married couple. Ostensibly, they are together. What is happening? Judge's face.
No, ma'am.
All right. Ms. Alcala, do you have any witnesses or testimony you want to offer?
I do not.
Okay. Did he move back in with the family the end of 2021?
Absolutely not. He moved to Colorado and we picked him up in October of 2023. And from there he started a job. And he
I'll get the
started providing in December. Yeah. Yes, he did visit my children. Yes, he has been in my house in and out, but he didn't start he didn't move in with us or be consistently helping and supporting them until November 2023, and we married in December.
Okay. So, all right. All right. Anything else from anybody?
So I'll get the proof from the DMV of my address switch in 2022.
Well, sir, you should have had that here with you today. This is the hearing right now. So if you have anything you want to present, this is the time to present it. You've testified, she's testified. I see the court order. I see your marriage license.
All the cash app I was sitting providing for my kid as well. I have information of that as of me providing for food and clothes.
Okay, well, child support was ordered at that time. Again, if you don't have any proof today, this is what's going to happen. I'm going to enter a judgment, okay? Do you have any documentary proof you want to offer?
Yes, cash app. I have our documentation of what I've sent directly to
All
Judge.
right, let's present it.
Put your money
Okay,
receipts,
let me go to my
bro.
thing here.
Bring
Okay,
your
and
receipts.
it has to be before November of 2023. That's what we're talking about.
Oh, before 2023. Well, this
Yeah.
cash app I didn't have until after, so no, I don't.
Oh,
Okay.
funny that.
All right, then I will enter a judgment against Francisco Martinez for past due child support as of November 30th of 2023 in the amount of $38,179.73, and for medical support arrears in the amount of $11,285.30. Also, as of November 30th of 2023, I will order Mr. Martinez to pay $250 a month toward the child support arrears and $100 a month toward the medical support arrears beginning on May the 1st of 2026 and continuing thereafter until those amounts have been completely discharged. I'll tax all court costs for today's hearing against Mr. Martinez as billed by the District Clerk of Hale County. And I believe that concludes all the issues that are before the court, Mr. Benishek, in view of the fact that you have non-suited your modification.
That is everything, Your Honor.
All right. If there was a non-disclosure in the prior order, I will continue those non-disclosures of addresses and identifying information. I will, and this order will be signed once it's prepared by Mr. Benishek and forwarded to the court through the e-filing system. Every party to a hearing before the associate judge is entitled to a de novo hearing in front of the referring court. The de novo hearing must be requested in writing within 3 days of the notice of the substance of my ruling and served on the other parties to this action. It must specify what issues will be heard by the referring court. The referring court will set a hearing within 30 days of the request, but the requesting party must obtain a setting from the court. If one party asks for de novo, any other party may ask for one within 3 days of the initial request. Nobody asked for de novo.
Her ruling becomes the whatever she says. Ugh, Adam, you fell asleep. And we're on our way out. On our way out. I'm gonna make blueberry muffins. Good night. I talk about Bruno. I'm gonna make blueberry muffins. I think a lemon. I don't know, something to do with lemon. I have 3 lemons. 3 lemons. Oh my goodness, you guys. Thank you so much for being here. I'm so excited and thankful and happy that I saw you guys. I know I have a very busy next few days. I don't know what time tomorrow will be. And I don't know what time Monday will be. They'll be in the afternoon. Oh, Vicky, it's like I read your mind. I knew what you were going to ask me. I knew it. I just don't know. I have an extraordinarily busy 2 days coming ahead. Any chance of live chase? I fucking hope so. That would be perfect. Maybe. Depends on what time. I don't want to interrupting. But a live chase we all love. Sometimes it brings people out of the woodwork, you know? Long missed friends and all. Anyways, do me a favor. Remember that I love you and I'm proud of you. And I will see you in the next video. It'll be tomorrow afternoon. Well, afternoon for me, evening for you. Love ya. Bye. Okay, bye.
Always done, ready to ride.